Hi, I'm Matt DeTura, an attorney at Keller & Heckman, and from time to time in the Video Minute, we like to bring you a different perspective on telecom issues from one of our attorneys outside the telecom group, and that's why I'm here today with K&H partner Manesh Rath from our Labor and Employment Group, and he's here to give us a perspective on an important issue to utilities and public safety entities, and that's the legal issues involved in the difference between an employee and an independent contractor. Manesh, why should a company care about this difference, and what sort of liability issues do they have to deal with the difference between the two?
That's a great question. The problem for employers is that when they deal with employees, they're under a different set of regulatory and legal requirements than when they are engaging with independent contractors. With employees, they need to deal with the National Labor Relations Act, federal and state discrimination laws, the Occupational Safety and Health Administration's regulations and standards, and wage hour laws, which impose requirements for minimum wage and overtime. Whereas with independent contractors, you would hope that a contract would govern the relationship. But in addition, two issues that come to mind are to make sure that if you have a subcontractor that in turn has employees, to make sure that that subcontractor has a certificate for coverage for workers' comp, and to make sure that your own coverage contemplates the possibility of uncovered subcontractors or independent contractors. And in addition, that those employees of a subcontractor or your independent contractors might try and persuade a court or an agency that they were misclassified as independent contractors and that they should really be classified as employees, and thus try and avail themselves of the protections and benefits of the laws we just discussed, notably the requirements for minimum wage and overtime payments.
Now, you mentioned subcontractors a few times. Say for sake of argument, I have a subcontractor working on one of my tower sites. Could I be held liable for my subcontractor's employees?
Yeah, that's a great question, too. There have been a couple of cases coming up in the past 2 to 4 years that really shed some light on this, and I think the results were surprising. In the context of a Occupational Safety and Health Administration citation against an employer, they alleged, the Occupational Safety and Health Administration alleged a safety violation. The employer was a general contractor and said, we shouldn't have this citation issued against us. Our subcontractor and its employees created the hazard. None of our employees were exposed to the hazard, so it's not fair for us to be issued a violation citation. And so the court disagreed and said, if you have control of the facility, and you can therefore abate any safety hazards, you too can be liable. Both the subcontractor and the general contractor can be liable, and OSHA can properly issue a citation against either. And again, 4 years ago, an important case came out involving the Fair Labor Standards Act, where a general contractor hired a subcontractor, who in turn hired its own employees. That subcontractor failed to meet its obligations for overtime payments under the Fair Labor Standards Act, and the court held the general contractor liable for overtime payments for the subcontractor's employees. Some of the issues that it locked in on in order to arrive at that decision were, well, for one, the subcontractor was simply unable at judgment to meet its obligations to pay those overtime payments. And another, the court looked to the fact that the general contractor had provided safety training and skills-based training so that the subcontractor's employees could do the job. And while they were doing the job, the general contractor was providing supervision to make sure that the job was done correctly in terms of quality control and that there was safety compliance. And the court said because of that, if the subcontractor hadn't paid its overtime payments to its staff, the general contractor had to pick up the tab and pay that overtime responsibility to the subcontractor's employees. It's an interesting development.
Now, I've heard that the Obama administration has made employee misclassification a serious priority.
That's right. The administration's Department of Labor has said that this is one of its top priorities, to go after employers that have classified their workers as independent contractors and have misclassified them, and the Department of Labor really believes that they should be employees. And so we've seen a rapid rise in enforcement actions by the agency as well as lawsuits over the past 7 to 10 years, even including class actions that can be extremely costly for employers, and we've been working with employers to try and defend those.
Excellent. Thank you for your time, Manesh.
Thank you.
For more information on this or any other telecom issue, please contact the link at the end of the video. Thanks for your time.